It's Trial Tuesday, and today we're talking about the statute of limitations in South Carolina and what it means for those dealing with long-term legal battles. As always, attorney David Aylor is here with all the information. Good morning to you.
Good morning.
First of all, for those of us that, everyone watching, just define it. I remember it from legal class a long time ago, but what exactly is it?
Well, that's the issue. A lot of times people don't understand exactly what it is. But basically what you're talking about is the period of time that you're able to bring litigation, legal action against someone or some company or some formation of a business simply based upon something that occurred. But a lot of times people get confused about that because they look at it as it's all a fine line, and it's really not. It depends on what type of claim you're talking about. Obviously, the earlier that you try to bring a claim, the better it's going to be in regards to safeguarding yourself from it. But essentially, if you think about your basic type of accident, car accident, whatever it may be, you're going to look at around a 3-year period. And so right there, that 3 years, it means that you have to file a lawsuit. So people get confused. Sometimes they'll try to negotiate things on their own, or they'll come back later after something they realize is something like a construction defect at a house, and they run outside of it. So what's important, if you have any type of incident, whether it be some sort of damage to your home, maybe some sort of malfunction within some sort of equipment you may have, or of course any type of accident, as well as medical malpractice, you want to at least go consult with an attorney originally. A lot of people, again, will try to deal with these things on their own. Maybe they'll put it on the back burner, decide they're going to worry about it later. And not only do you have to worry about the statute of limitations, you have to worry about your case being damaged from the standpoint if there's other statements that need to be taken, evidence that needs to be collected. All the time you have witnesses that maybe either disappear or they really forget what happened. So when you go back later down the line, it may be a lot more difficult. So it's not just about the legal side of it, there's also a practicality side of it.
So let's say you're filing a claim or trying to legally proceed with something, and then your statute, you hit that 3-year mark. Can it continue, though, to go to courts because you're already in that process?
Yes, if you've already filed, at that point you've preserved your right. The issue comes when you've gone beyond that. So if you go beyond that and you've not actually filed, and you haven't gotten a tolling agreement, which is to get the other side to agree to say, hey, we're negotiating this, you're not going to file a lawsuit, it's not going to be necessary, without having that type of documentation. But yes, because you do have suits, unfortunately, depending on what type of case it is, it may drag out for several years beyond that initial date of injury or the accident. However, as long as your attorney's filed on your behalf, your rights are preserved and that timeline goes away. You
said you're an average of 3 years. Does that vary by state? Is that just for South Carolina?
You're going to have to look exactly, depending on where you are, what state you're in, as far as what their statute of limitations are. Each state, even ones in the South, even though you think a lot of the southern states have the same laws, they don't when it comes to that. So it's very specific. So if you are to talk to an attorney, you don't want to call a relative who may be an attorney in another state and say, hey, here's what happened to me, how much time do I have? You need to get an attorney in that state. And again, it may be that you have plenty of time where you can work these things out, but you at least want to know those deadlines. Attorneys themselves often in different types of cases don't file a lawsuit until the point that they have to. Depending on what type of case it is, it may be something that you can negotiate without having to go that route. However, you always have that date in mind, and so you don't want to get past that date before you go ahead and file.
Sure. Is this something that you frequently see, that someone comes to you and you're like, I'm sorry, it's too late?
You do. You see that a lot. Sometimes something will spurn. Maybe they'll watch this show and they'll hear something issue that they think is similar that they had, and then you try to work that out with them, and it turns out that the date's passed. So you want to, even at whatever point, whether you decide to go ahead and get an attorney, at least consult with one to try to determine what your date is. But I would say statute of limitations is an issue, and also just inaction as a whole. Even maybe if your statute of limitations has not run yet, it's 2.5 years later, it's going to be very difficult to move forward on that case because insurance companies per se can look at it and go, hey, look, you hadn't done anything yet. Why is it going to make a difference now? And maybe if you were injured or something happened, there's a lot of time that's passed in between, and that may be the actual cause of what has happened to you now, not the original injury 2.5 years ago.
As we learn with anything and everything we discuss with you, consult an attorney right away.
At least try.
Best of advice.
And I don't mean a Google attorney. I mean an actual physical. You can Google and find an attorney, but actually go in and see them.
Perfect.
Exactly.
All right. Trial Tuesday with attorney David Aylor. Thank you so much for being with us. We've got much more Low Country Live in just a few. Stick with us.